All rise. The Supreme Court of Guam is now open. Honorable Chief Justice Robert J. Torres presiding.
Morning, councils. You may be seated. Will the clerk please call the case?
This is Supreme Court case number CRA-024-013, People of Guam Plaintiff Appellee v. William Robert Reyes, Defendant Appellant. Appearing for Plaintiff Appellee is Attorney Nathan M. Tennyson. Appearing for Defendant Appellant is Attorney Heather M. Kittigwa. Panel members consist of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine Merriman. Your Honor, Attorney Kittigwa reserves 10 minutes.
Ms. Kittigwa, you may proceed. And welcome to Appellate Advocacy. Good to have you here.
Good morning. Good morning, Chief Justice Torres, Justice Merriman, Justice Carbolito. May it please the court. So at issue today is whether Mr. Reyes was denied a fair trial. And we believe he was not allowed to have a fair trial.
Can you speak up a little?
Sorry, is it?
Yep.
No. So at issue today is whether Mr. Reyes was denied his right to a fair trial and whether his constitutional rights were denied to him. We submit that he was not allowed to have a fair trial and that in fact his constitutional rights were violated. In 1935, the United States Supreme Court made clear that the prosecution's duty is not to simply win a case, but to ensure that justice is done. In that case, Berger v. United States stated in no uncertain terms that the prosecution must refrain from improper methods calculated to reach a wrongful conviction. So that's the circumstance that we have here, among other things. We have a wrongful conviction that was achieved based on the following improper methods, all of which deprived Mr. Reyes of a fair trial. Number one, arguing facts that appeared nowhere in the record except in the prosecutor's own statements. The prosecution repeatedly stated that the victim had experienced burning to show that she had in fact been penetrated, but the victim never said anything of the sort. That appears nowhere in the record.
That was done in her closing, right?
It was done in her closing. It was done in arguments to the court as well. But yes. But
doesn't the instruction that statements by attorneys aren't evidence and if you assume the jury relied on that and just relied on the actual evidence and there was no objection, so it's a plain error analysis, why doesn't that cure the issue?
Well, because there are a couple of things that go to that. One is that it makes it seem as though there's more evidence than there is. And I think that under the Borg case, what we're looking at is who is actually saying these things. So when a prosecutor gets up and in closing and refers to facts that aren't in evidence, there's a certain amount of credibility that is given to that people look at when they're reviewing the evidence. And so to say that is highly prejudicial. So I don't know that the instruction actually cures that. It is problematic that there wasn't an objection. That may have been a tactical decision. I don't know. It's not clear from the record. But I do know that that should have been corrected and it shouldn't have been made. Because in this case, it was actually a very difficult case for the government. It was, I think that the trial was 2.5 days. It wasn't like a 20-day trial and certain things were kind of lost in the confusion of a whole bunch of evidence. This was a short trial. It was a difficult trial. There was a decade or so that had passed between the original alleged events and these events coming to light. There was no other circumstantial evidence. The evidence really was just from the alleged victim's own statements. So there was no other evidence besides evidence that she'd experienced pressure to bolster or support her assertions that she had been penetrated. So I think it actually is fairly significant. This isn't a case where, there were a lot of other examinations or any outside information. So that's why I think it's highly prejudicial. And I do know that when we talk about jury instructions, we do assume that jurors follow them. But in this particular case, I would submit that given the state of the evidence, given the highly prejudicial nature of referring to facts not in evidence, that it's a little bit more complicated and more prejudicial than in a normal situation. Because this reference to evidence that didn't exist was used to establish the elements of the case and of
So
the charges.
you, Ms. Caterway, you said that the prosecutor, I'm sorry, defense counsel did not object, and so it's, I assume, subject to a plain error analysis. And while you are arguing that the defendant was substantially prejudiced, we still have that four-factor in exercising our discretion. It's not something automatic. I think you agree with that. It's not a fundamental type error. And so can you say in terms of that four-factor, in terms of protecting the integrity of the judicial process?
Well, I think that in terms of protecting the integrity of the judicial process, I have to go back to the Berger case where we're looking at what actually goes into finding a conviction and what is the justice for that. Is this really serving justice to allow a prosecutor in a closing argument, or really in any aspect of the case, but particularly in a closing argument where the purpose is to sum up the evidence and present it to the jury as to why the prosecution should win. So if we have a situation where we're looking at what goes into that equation in terms of offending the system of justice, we can't allow the prosecution to introduce at that critical juncture facts that are not in evidence, where it's nowhere in the record. So I think in terms of that analysis, that's really quite an affront to the system of justice. And it's important because we need to make sure that a conviction is based on the actual evidence. So if we allow people to do that, it's really a slippery slope as far as what ends up coming into the mix. So, but that's not our only area of disagreement as far as whether this conviction was appropriate. We also think that the use of leading and suggestive questions basically substituted the prosecutor's own testimony for that of the witness. And the court has the record in front of it, it can look at that. But essentially, we have a victim who repeatedly testified that she was not penetrated by Mr. Reyes. Repeatedly. This isn't, just a flyby thing. So it's only after the prosecution asks her questions and inserts, again, facts that are not in evidence into the question that the responses come out. So it's really inappropriate. I think that's misconduct as well. And then also using prejudicial information concerning Mr. Reyes's arrests, which were brought in not to show that he was untruthful as to the questions he was asked, because no one disputes that he was in fact truthful in response to the question he was asked by his own attorney. When you look at the record, it's quite clear that the only reason this information was brought in was to show that he was a bad man or shouldn't be trusted or wasn't telling, was telling stories or was just bad. So it was really inappropriate. Now, these methods were improper, to be sure, but they also denied him of a fair trial. He has the right to a fair trial. And those procedures denied him of that. But also the court's trial decisions also denied Mr. Reyes of his right to a fair trial. So when we look at the introduction of these materials as to Mr. Reyes's prior arrests, the court did not conduct any balancing that was required under Rule 403. It's just nowhere in the record. The correct law was not applied as to the introduction of that information. It's just incorrect completely on its face. And we believe that the failure to grant the motion for a mistrial based on that erroneous decision, those erroneous analyses and decisions also was a problem.
The government argues that this otherwise inadmissible testimony could be admitted because opposing counsel opened the door by creating misleading impression about the contents or significance of his prior arrests.
Right. And Your Honor, the problem with that argument is that it is trying to look at some of the intent or counsel's intent, but that's not an issue. The issue is, what was the question that was asked? I mean, there could have been all kinds of intents, but we don't know what they are. We have to look at what the actual question was that was asked to determine whether the door was opened. So the questions on their face are quite clear, and the defendant quite clearly answered the questions that were asked. So now, if he had answered them untruthfully, or if there had been some other situation, maybe we'd be arguing something else. But none of that is here. The prosecution does not deny that Mr. Reyes was truthful when he answered those questions. So there's no door
Well, they said
opening
he
here.
testified incompletely, right? I mean, that's their argument, is that he opened the door by testifying incompletely as to the criminal history.
Well, the record doesn't show that. The record is actually with respect to convictions as to particular events, and those track the language of the evidence code. And I would also note that it is often the practice for defense counsel to ask those questions so that it's just addressed quickly and judiciously, efficiently. But when we look at the actual question that was asked, it doesn't open the door beyond what was asked. So I don't think that any argument that he was somehow less than truthful or incomplete really should be given any time at all, quite honestly, because the question says what it says and the answer says what it says, and they match. So there's really nothing here to suggest that. Now, the other argument with respect that the government made with respect to that has to do with the hearsay. So it's not only just that it's incredibly prejudicial to bring these things in for no recognized reason, and we don't believe that the door was open at all. But the other issue is the hearsay. So there has to be hearsay in order for these things to even be said in the first place. I mean, the hearsay is the source of that, right? So to the extent that the government is trying to introduce things that other people are saying that cause arrests to be made or other things to happen, then the government would have been obligated to bring those folks in. Again, I think that all of that is still subject to the court, the trial court, performing the balancing analysis that is required under Rule 403, because the court can't just let anything in without taking that time to conduct an analysis about whether it's even probative, because this information had nothing to do with whether these acts happened in the case. It doesn't have anything to do with that. But still, if the court felt that it was somehow relevant or probative, it still was obligated to conduct that balancing analysis. And there is nothing in the record to indicate that the court did that. So we think that that was error as well. And that was just incredibly prejudicial, because all that information did was to paint the defendant in a very poor light, that he was a bad man. And this is exactly why we have the prohibition against introducing that kind of evidence into a trial, because it is so prejudicial, and because that is something that will skew the results and will achieve an unjust result. So that is why that is usually prohibited. And that's why the analysis is required. We also believe that the failure to grant an acquittal based on the lack of evidence that Mr. Reyes actually penetrated the victim there should have been an acquittal granted on that. The evidence was quite clear. The victim said many times she was not penetrated. When we look at the evidence, that's what's clear. And even under the case law, even under Mendiola, the standard is whether there's a breach. Well, I'm not really sure what that means in this particular case because the evidence talked about passing. It didn't talk about entering. The prosecutor could have asked that very question. Did his fingers enter instead of just passing? Passing up, down, sideways, and we don't know. And it's up to the prosecution because they have that burden to come forward with that.
Well, that may be the case with the CSC1. Does that also apply to the CSC2 conviction?
The CSC, well, we believe that the entire, just to take a meta view, we believe that the entire trial was tainted because it was unfair. So with respect to that, but yes, with respect to the CSC2, I mean, to the extent that it's just involving touching, then that's a different analysis. But the mistrial was based on the CSC1. That was the motion for, I'm sorry, the motion for acquittal was based on the CSC1.
But the evidence there was highly conflicting, and the judge decided to send it to the jury. And I understand the arguments that the trial court aired in certain rulings that let it proceed in reference to sending it to the jury. But in reference to the sexual penetration, where you had the conflicting evidence in both the direct and cross-examination, wasn't that sufficient for the court to send it to the jury to decide?
No, Your Honor, we don't think it was. And the reason for that is because the conflict was created by the prosecutor, the prosecution's poor questioning and improper questioning that was leading and suggestive. So if we hadn't had the leading and suggestive questions, I think it would have been quite clear. So for the trial court to allow those leading and suggestive questions, that is what created the problem. So no, I don't think. But
generally, I mean, leading questions are not absolutely prohibited by Rule 611.
They're not necessarily prohibited, but in the case of a of the prosecution, it is the prosecution's witness. So there is some leeway that's given, for example, for young children that are having a difficult time telling their story. In this particular case, we had a 20-year-old woman who was a nursing student who was well-versed in female anatomy. So this is not the same kind of situation.
But it's for events that occurred 10 years prior.
Well, but she still has the ability at this particular point in time when she is testifying to tell her story. Now, it would have been different perhaps if the trial had taken place when she was 9 or 10 years old, but it didn't. It took place when she was 20, when she was a nursing student. And there's nothing in the record to indicate that she didn't understand the questions. Not once, I don't believe, did she say, you know, I don't get it, or, you know, I don't recall any instance like that. So she understood the questions. She answered the way she did. Whether the prosecution liked the answers that they got is not a reason to all of a sudden permit leading questions. So I think that the questions were whatever they were and her answers were whatever they were, but the prosecution still is not entitled to ask leading questions. And if the prosecution wanted to ask leading questions, then I think it was obligated to seek permission of the court to do so.
But I think the stronger argument is the 403, the lack of a
Yes.
403 analysis, and in reference to even if the court did allow, because we give general deference to the trial court and its exercise of discretion in reference to leading questions. But I do grant you that it is of concern that there was no 403 analysis.
That's correct, Your Honor. And, you know, and we do think that that is quite problematic. But I would also say this, that while I do believe that each of these incidents that we have argued in our brief warrants a finding that Mr. Reyes was deprived of a fair trial, together, I think it's overwhelming that the trial was just not fair. You cannot have facts not in evidence argued. You cannot have a prosecutor asking leading and suggestive questions that give that imprimatur of reliability, because the prosecutor is a representative of the state. But you also can't have prejudicial information and evidence admitted without evaluating whether it's even probative in the first place, and then whether it's going to be prejudicial. I mean, I don't know that there's any relevance to that information, but it came in and we don't really know. I mean, we don't know anything more about it because the court didn't take the time to do that analysis. So between that, and then again, the question of whether there really was a crime here was obfuscated by the prosecution's suggestive questioning. So it basically changed the tenor of the case. You can't have a prosecution that is testifying for the witnesses. So for those reasons, I mean, we think that Mr. Reyes should get a new trial. I think it's very unfair.
It seems that her testimony as to CSC2 was pretty straightforward. Do you think that count can survive and just reverse on the first degree?
Well, I think when you have a trial that is so tainted by unfairness and improper activities, I don't think you can have that one survive. I don't think that when we look at a trial, we're not looking at, we're not just picking a couple of the pictures out of the pile. We're looking at a movie and we have to look at the whole movie as a whole, because that's what the jury does. So it's up to the jury. Just because somebody testifies however they do, it's still up to the jury to consider all of the evidence, including, whatever is said with other witnesses.
But when the jury instructions in reference to the pertaining to CSC2 address as to what are the elements that the prosecution has a burden of proving, and you're suggesting that because of this, the way the trial was conducted was so tainted that the jury could not separate its obligation in reference to CSC2? And
yes, I do, Your Honor, because the information that came in with respect to Mr. Reyes's prior arrests really tainted everything. Because at that point, I think that the jury, and it was designed to do that. That was by design. I think it's very clear.
so it wouldn't have to do with the sufficiency in terms of sexual penetration or the leading questions, but you're saying that the misconduct in terms of the closing arguments and the possibly prior arrest and indictment information, that issue is affects the CSC2 analysis?
I do. I am saying that because I think that those that misconduct and that prejudicial, highly prejudicial evidence that came in that deprived Mr. Reyes of his right to confrontation as well, right? Because he wasn't allowed to question whoever these people are that are making whatever these things are. I mean, even if we look at what was actually said as to the prior arrests, when he was asked about those arrests, we don't know exactly what those arrests were about. We don't know whether it had to do with somebody stealing a bicycle. We don't really know, okay? But then in closing, that was converted into, do you believe him when he has had these other cases involving children? I mean, that's just incredibly prejudicial. But again, because there was no analysis to evaluate that, there was no limiting instruction given on that information. I think the whole trial was tainted. So, because again, we have to look at the trial as a whole. We can't just say, well, at this particular time, this was okay, but then this, which was highly prejudicial, we think it only affected this. I think when there's prejudice, when there's highly prejudicial behavior and misconduct, it infects the entire case. And so I think we have to look back at the entire case and not just sort of parse out bits and pieces. So.
All right, thank you, Ms. Kennedy. You'll have 6 minutes remaining.
Thank you.
I mean, Ms. Kidwa. Sorry. Mr. Tennyson?
Thank you, Chief Justice. May it please the court. So we have a lot of issues before us today. And I do agree with Ms. Heather regarding, and I'm going to cite to United States v. Young. Supreme Court of the United States stated, in reviewing criminal cases, it's particularly important for appellate courts to relive the whole trial imaginatively and not to extract from episodes in isolation abstract questions of evidence and procedure. To turn a criminal trial into a quest for error no more promotes the ends of justice than to acquiesce in low standards of criminal prosecution. So there's a weighing here. And I would say that our legal standards do contemplate that there's going to be inevitable error along the way in pursuing justice and in handling these kinds of proceedings, whether that errors on the defense side or the prosecution side. Things do arise, and our law is designed to try to mitigate those things when they happen. And I'm just going to go through, I suppose, each item in order, and if there's any questions that delineate, please let me know, and we'll get everything covered. So I'm going to start at the beginning regarding the judgment of acquittal. So Mr. Reyes claims it was error for the trial court to deny the judgment of acquittal or the motion for judgment of acquittal. And the standard under that is that evidence is viewed in the light most favorable to the prosecution. That's People versus Anastasio. So after hearing the evidence, what the trial court would have been looking at is, would a reasonable trier of fact be able to find, in this case, the two elements of first-degree criminal sexual conduct. For this case, those two relevant elements are, was the victim under the age of 14? And is there evidence of sexual penetration? And sexual penetration being defined by statute as sexual intercourse, cunnilingus, fellation, anal intercourse, or any other intrusion, however slight, of any part of a person's body, or of any object in the genital, et cetera, et cetera. So there was definitely testimony that the victim was under 14 at the time of the conduct. And while there's some back and forth about the evidence of the victim saying, no, I wasn't penetrated, and then being on redirect with some leading questions, establishing some anatomical and location details, there is sufficient evidence here that a reasonable trier of fact could look at this and say, there could have been attempted first-degree CSC, there could have been first-degree CSC, or there could have been the CSC.
But I think, Mr. Tennyson,
Yes.
the argument is that while there was the conflicting evidence,
Mhm.
as Ms. Keto has pointed out, although she says that that's problemsome in itself, that coupled with the fact that the court never applied a 403 balancing test before it decides whether or not to admit that testimony, and as a result, make it such that it would be in a position to allow the case to go to the jury. That was the error.
Yes, Your
That
Honor.
was the problem, substantial problem.
Yes, Your Honor, and that's a nice segue, because that does lead us into the next question of, well, what is the nature of the evidence, the sufficiency of the evidence, and in this case, the admissibility of the evidence. And I believe a big portion of this leads into the discussion about leading questions. And the first note I would make is that there was no objection to these questions from defense counsel. I don't recall seeing an objection in the record. So for the court to have that analysis, I think first an objection would need to be raised. And then there'd be an assessment of, is this appropriate? Is this not appropriate? And since there's no objection, we're looking at this for plain error. So prejudice, clear, obvious error is reversal necessary to prevent a miscarriage of justice. And really, in regards to the leading questions, I would delineate between, well, there's a couple moving parts here. So it was the government's witness, the victim was, but it was on redirect. There had been the original direct, and on cross-exam, defense counsel had asked, were you penetrated? And the victim just said, no, I wasn't. And the people's response on this particular issue is that penetration is different from the understanding on the street of that term. It's more of a legal definition as we're using it. There's elements, there's case law on it. And while the victim does have some nursing background, there's no indication that she had background sufficient to determine penetration as a legal element of criminal sexual conduct. And really when during redirect, the nature of the questions, and we have some of them here, just one second. It's page 12. So many of the questions were either to get more specific and anatomical detail as to where exactly the conduct occurred, what happened, and to reconfirm some prior testimony the victim had, such as, okay, so earlier in his questioning of you, he'd asked if he entered the vaginal opening and you said no. Remember saying no? So she did say no. And also under Guam case law, entry of the vaginal canal is not, or vaginal opening isn't penetration. It's the slightest, even the slightest penetration of something like the labia majora. And that leads into questions regarding where exactly did his finger enter? Was it past the labia majora, or at other times prosecution said the lips, to help with assisting the victim in articulating more factual aspects of this rather than the victim's subjective understanding of what is penetration. Was I penetrated? And regarding the victim's knowledge, there's been back and forth on the defense side. At trial, the defense counsel, is on the record as saying the victim doesn't understand anatomy. There's a lot of questions about the victim's training, experience. I have no doubt that she has been trained to do assistive care and initial nursing, but at the time of the trial, I think she was in her first year of nursing. And I think the record indicates that her, if I was in law school in my third year and people asked me questions about technical Latin terms, I might know the principles, but I wouldn't be able to, of my own cognition, use those words. It does seem that the victim had some issues with articulating certain things anatomically, of providing that kind of detail. And the redirect questions were necessary to assist with obtaining that information and also with rehabilitating the victim after she had just kind of presumptively said, no, there was no penetration. Well, what do you mean by that? What is penetration? Where's the finger actually? That's what these questions were more focused on, and this is where they were going. So insofar as they're, not aggressively leading, but they're giving some information or terms to assist the victim. There's one question in particular. So did the tip of his fingers pass your labia majora, the lips? Answer to that could easily be no, it didn't. She said, yes, it did. But it didn't end with didn't it, or wasn't it the case that? Where did the finger stop, before or after? Where did you stop after the stop sign? Was it before or after the stop sign? Not a leading question in a sense of, other than giving them the terms of stop sign, in this case, labia majora. And the expectation here is with the clarification provided that the victim knew what was being referred to and was able to then answer knowledgeably. And for those reasons, I'd say the leading questions were appropriate, and that information should have been considered by the trial court in gauging the judgment, motion for judgment of acquittal. There was no objection, and we are looking for plain error. I think that the trial court would have had discretion to allow those questions had there been an objection, particularly because, and I don't remember the name of the case, and I didn't bother memorizing it. It's out of the First Circuit and not super helpful, but it does discuss how an appellate court shouldn't overrule a denial of a leading question like that unless the question would have elicited specific information necessary for developing, the case, findings of fact. That information here was necessary for those issues at the very heart of the case, because it involves sexual penetration. Um, and we have a chunk of the issues involved. I'm actually going to get to these last. I'm going to just discuss the burning reference during closing argument first. That's a little more straightforward than the issue I'll close with. So 4 statements were made by the prosecution regarding burning, 3 at closing argument, 1 to the trial court when the jury was out. I believe they were discussing a motion or something. And there was no objection. And I'd say it didn't register it for an objection because I disagree in the severity of the misstatement. I think it didn't catch any attention. And while there is no evidence in the record that the victim stated she had a burning sensation, a burning feeling at any point, there was other sufficient discussion by the victim that she had pain. She had pain for a day or 2 after the event. And if we were to go back to a closing argument and replace every instance of burning with pain, I think the meaning is still there. The phrase, burning isn't in the record, and yes, ideally prosecutors shouldn't cite to facts outside the evidence. However, this ties in the beginning when I said there will be inevitable errors. This was a 2.5-day trial. Prosecution and defense both look at materials before that. They have lots of things in their head. And my suspicion is that at some point in the past, there had been a discussion. The victim said there was a burning. She didn't at trial. And I think there should be some leeway given with the understanding that things can get confused in our heads. We can mistake certain things for others based on when we heard them. And we balance that with what's the prejudice of the misstatement, of the misrepresentation. The burning statement is equivalent to pain, which is in the record. There is a jury instruction saying, hey, jury, if you heard something from the attorney in closing or an argument that doesn't match your recollection, don't rely on that. Rely on your own recollection. And really, at the end of the day, plain error, we're still looking for substantive prejudice or substantial harm to justice. I think the evidence is sufficient to overcome the misstatement.
But in reference to your argument, so first, if I understand your argument is that in terms of this, the first 2 elements of plain error was error and it was clear and obvious. You're saying that the description of pain and the use of word burning are one and the same? That
I wouldn't say they're one and the same, Your Honor. They do definitely have different semantic meanings, but I think they're both indica of penetration, and that's what I mean by saying they're interchangeable.
So if we reach the substantial prejudice element in terms of the plain error, I mean, the issue of penetration was highly contested, and it was there was evidence on both sides, and so in terms of the argument leading the influence of the prosecutor and giving credence to that, in fact, she was penetrated because there was a burning sensation. You don't feel that substantially prejudiced the defendant in reference to that 3rd element of the analysis? I'm sorry, that goes to the issue of whether or not she was penetrated.
Yes, Your Honor. Based on the record and the facts and the testimony, I think that it wasn't in the evidence. I don't think it was prejudicial because there is still the evidence and the statement of pain persisting over a day or 2. And my preference would have been that that word had been used instead of burning, but I think that they're both equivalent in terms of indica of supporting the victim's statement or conclusion as to penetration. She experienced the sensation of pain. And it is a different sensation from burning, but burning is also painful that we'd expect. But not to say that there isn't a misstatement of the facts, Your Honor. It's more the issue, I think, is, and there is a discussion in I think if we're looking at it from that perspective, what I think is helpful is looking at elements other courts have used for analyzing misconduct in these kinds of statements. And some of those elements include the gravity or severity of the impropriety, its relationship to the issue of guilt, and the strength of the government's case. And combined with the other evidence of pain and conduct, I think that in the broad picture, it is error, but it's not prejudicial error because there is other evidence that if the jury had been told instead pain, I think the jury would have come to the same conclusion because they're both indica of the conduct. And I mean, jury instructions were given, and we hope that the jury would have had recollection that burning wasn't used. We don't know. We can't go back and ask them, but they did have other evidence they could rely on. I think the issue that has drawn my attention most in this case is when Mr. Reyes took the stand and was questioned regarding his criminal history.
That also was the one that got my attention as well.
And that's the issue I think we struggle. That's our uphill battle in this case. And to begin, I would just clarify that this is what defense counsel's question to Mr. Reyes was after establishing where do you live, you know, this kind of stuff. And I guess before we begin, as far as any criminal history, I mean, have you ever been convicted of a felony? Mr. Reyes says no. Have you ever been convicted of a misdemeanor? Immediately, Mr. Reyes says no. Involving lying, cheating, or stealing? Again, no. So, and there's a discussion of, well, we don't know what the intent of the question was, but there's lots of speculation about the intent of the prosecution's questions. I'd say we don't look at the intent, we look at the impact of the question and the resulting answers. So the question is framed as, about your criminal history, have you been arrested for a felony implicating dishonesty? Not the felony just involving dishonesty, but the felony could be imputed to that, or a misdemeanor involving dishonesty. Answers both no. No following up question, have you ever been indicted? Which is relevant criminal history. That is part of whether or not it ended up going into a criminal proceeding or a trial or not. A grand jury convened, looked at evidence, found an indictment. It was in response to that indictment that Mr. Reyes was arrested. It was involved in that indictment that Detective, I can't pronounce her name, I apologize. The detective and the three females were involved.
But under what rule of evidence did the court allow the evidence that you're describing to come in?
I would say that that is under opening the door. And I would also say that the evidence in itself, so an indictment was shown to Mr. Reyes, but it wasn't admitted into evidence. And I would even say that the questions about the detective and the three females and the Manitonas were asked to assist Mr. Reyes in recollecting the particular incident inquired about. I think that line of questioning, it did eventually culminate in showing Mr. Reyes the indictment, to which he said, no, I've never been indicted. And then prosecution immediately stopped that line of inquiry. There was no discussion of what was entailed in the crimes beyond just three females, the detective, and indictment. It could have been something unrelated.
So when the court allowed that in under Rule 609, you said that the court, you're saying the court did not err in basing its ruling on Rule 609.
Yes, Your Honor. I do believe the trial court did not err, and I believe their reasoning was that the information about the arrest, the indictment, it was very general in nature. It didn't provide specifics as to information the jury would grasp onto or use to inform its decision.
But 609, I mean, they were using it for impeachment purposes. And doesn't 609 require that evidence be evidence of a conviction of a crime?
Yes, Your Honor. So my response on that would be, and this ties into, I don't remember the name of the case. It's a Guam case, but I believe that comes into effect. So if we want to present evidence of someone's, we want to impeach their character with that, we can only do it ourselves take the initiative in doing that if it meets that evidentiary requirement. Now, that evidentiary requirement doesn't apply if the defendant in his own defense takes the stand and these questions are asked of him regarding his criminal history that are 2/3 correct. They leave out the indictment. Had defense counsel followed up with a third question, have you been indicted? And Mr. Reyes had said, yes, I think there's no basis for this line of questioning, then there's a problem. If Mr. Reyes had said
So
no.
is our analysis then should be that regardless of whether or not the trial judge was correct in admitting this under 609 or not, so long as there's some other rule of evidence that will allow it in, it's okay?
I think that'll depend on the context, Your Honor, but I think generally if the context supports it, if there's a reasonable basis for its introduction that's colorable beyond just, I do disagree that this was just in there to show he was a bad man. I think it was provided to.
And there's no issue that it happened 20 years ago. And so the limitations under 609, even assuming that it's prior conviction, of generally that it should be no more than 10 years unless there's good cause for the court to determine that that time period is not reasonable. And so none of this analysis is relevant.
I don't know if the analysis is irrelevant, Your Honor. It does come in, in terms of having multiple balances and having multiple ways of looking at things. I mean, if 2 or 3 ways say it looks okay, I think there's a bigger provision that it's okay.
And the fact that the court didn't do a 403 analysis, even if the evidence, was admissible under 609, which is problemsome because that has to do with prior convictions, and you're saying the prior is more prior bad acts.
Yes.
And
to that, I don't believe there was a prior conviction. The indictment would have been its own separate thing and not really covered by the conviction requirement for admission of evidence.
and the trial court said it's one and the same, so it doesn't really make any difference.
I don't know if I agree that they're one and the same. I think the indictment has less finality than the conviction does because you can still be found not guilty on the conviction. I'm sorry, the indictment. But the indictment is still a component of criminal history. It's not just an arrest. It is a grand jury saw evidence and made a determination. And really the way to avoid the entire situation would be if defense counsel hadn't have asked about the criminal history. Particularly, defense counsel should have known that the indictment was there. Defense counsel shouldn't have opened that can of worms. And that's the danger of putting a defendant on the stand to testify is if it's somewhat related, if it's reasonably related, and it's necessary to create a full image, it's open game, it's open season. I would submit that in this situation, defense counsel probably shouldn't have asked that question, wouldn't have opened the door.
But let's say that it was potentially evidence of character that that his credibility could have been attacked under 608. But how was the questioning, how was it probative of truthfulness or untruthfulness? There's no evidence that he didn't answer truthfully. Yes. And to that, Your Honor, I would say it's because the nature of the questions themselves was couched in a way that excluded the indictment. You didn't just say, tell me about your criminal history. Have you been convicted of a felony or a misdemeanor? Didn't ask about anything else and immediately moved on to other questions. And but he didn't answer those questions untruthfully. No, he didn't, Your Honor. I agree with that. I think the concern is, and this is because of how the question was couched, about your criminal history. Let's talk about that. And then only asks about those 2 specific issues and there's an indictment in his history. And that I believe is part of criminal history. And I do think that by defense counsel not wrangling with that, it opened the door for the prosecutor to ask, well, have you been indicted? And
Then you go through the whole process. You don't recall this, you don't recall that, review the indictment. Does that refresh your memory? Mr. Reyes said, no, I haven't been indicted. He stuck by his guns, and he managed it. So yeah, I don't believe that the trial court erred on the motion for mistrial. I do think there was a reasonable basis for that question. And in regards to the hearsay, the Detective Emmergwin and the three females were referenced, the indictment was referenced, but there were no statements made from any of them. Nothing was read from the indictment. It wasn't put into evidence. These were all very general things. And I will again state that as soon as Mr. Reyes said, no, haven't been indicted, prosecution stopped, didn't dig into it anymore. They exhausted their ability to discuss criminal history, and they stopped. And in regards to potential remedies the court could look at if the court decides that, it's not inclined to uphold the convictions, particularly the first CSC conviction. And this could be due to evidentiary issues or other concerns of the court. There was a lesser included of attempted first degree criminal sexual conduct. And I think the record is particularly clear that there was sufficient evidence from the victim to provide that there was attempted penetration. There's something, the victim says that he tried to stick his fingers into her. And as we look at what really solidifies, I think, the jury's determination and decision in the conviction is there's four witnesses. There was the victim, victim's mother, victim's father or stepfather, and then the defendant. The victim's mother and stepfather both testified as to the victim's schedule, that she would be at the middle school, would ride the bus to the other middle school where her grandfather would pick her up, take her home until her parents could pick her up. The victim's testimony corroborated that. Mr. Reyes got on the stand and testified. He initially said, no, never happened. And then he kind of waffled on it, said, no, she was there sometimes, but we never did this other stuff. The father, the mother, the victim's testimony were all conducive to that, and they would have known their daughter's schedule and how she got home after school. The victim also testified that this conduct went for a while. He was rubbing her, his hand went down her pants. And I think a reasonable jury, on hearing the victim's testimony, could reasonably find beyond a reasonable doubt that if you're doing that kind of activity and rubbing someone like that, your finger is going to penetrate past the labia majora, even if they're wearing underwear. That's not a far way to go.
What about Ms. Skidera's argument that the errors in terms of prosecutorial misconduct, assuming the argument, not that necessarily is the case, of facts not in evidence, and the prior arrest and indictment in allowing that testimony so infected the trial that the jury was not able to separate the elements of CSC 1 and CSC 2, that just so influenced the entire trial. What's your take on that?
Yes, Your Honor. My take on that is, looking holistically at the whole record, it's hard to go back and look at, tell if the jury was influenced by something improper or not. There is this issue of the burning comment in closing of the dispute over penetration and the testimony in support of that, of the questioning regarding the indictment and the prior arrest. My hope would be that the jury, and they were given many jury instructions regarding recollection of evidence, attorneys aren't witnesses, and that you don't consider the question, and particularly in determining the facts, you must rely upon your recollection of the evidence. What the lawyers have said in the opening statements and their closing arguments and their objections or in their questions is not evidence. In this connection, you should either bear in mind that a question put to a witness is never evidence. It is only the answer which is evidence. And there's another instruction that discusses that an answer is only considered insofar as the answer relates back to it. So the questions about Detective Amaguen, 3 females, aren't evidence, and the jury was instructed to that point. And I think that's the challenge the court has before it, is to look at it, determine were those, is there prejudice here that would have infected the jury so that it was incapable of entering a just verdict. If that's the direction the court goes down and considers, my thought is that there is sufficient evidence, even if those issues had not been presented to the jury, to support a conviction, whether that be conviction for first-degree criminal sexual conduct, whether that be attempted first-degree criminal sexual conduct. I'm of the opinion that there's enough in there for a reasonable trier of fact to beyond a reasonable doubt find those. And with that, I have no more time anyway, so I'll rest. Thank you.
Thank you, Mr. Tennyson.
So I wanted to just respond, oops, a little shorter than Mr. Tennyson. I wanted to just respond to a couple of the points. One is that there was no need to rehabilitate the victim. She never indicated that she didn't understand or anything. And in fact, if we look at what the questions were, the real problem is that the victim repeatedly said that she was not penetrated. So the question was, and I don't think that this is rehabilitation. I think this is trying to get the victim to change her testimony altogether. So the question is, okay, so earlier meaning the defense attorney, in his questioning of you, he'd asked if he entered the vaginal opening and you said no. Remember saying no? Now, again, the vaginal opening, that we assume the vaginal opening that we're going past the lips, or we're entering into the lips. Okay, so we already know that the victim has said no, that did not happen. Answer, yes. Question, okay, so can you tell us, if you think you know the familiarity of the body parts, where exactly did his finger enter? Now, until this point, the victim had said consistently that there was no entry. So this is the prosecutor improperly injecting information, suggestive questioning, and this is a leading question on redirect. This is not an effort to rehabilitate the witness. This is an effort to change the witness's testimony altogether. So the argument that this was somehow to get more particularity has to be rejected, because this is a change altogether. So there's nothing on that. With respect to the issue of the burning versus—
Have those questions been asked on direct? Would they have been all right?
I'm sorry, if the question—
Had those questions been asked on direct examination? Would they have been okay?
No, it wouldn't have been, because it's a leading question, and it assumes facts, not an evidence, because there was no evidence that his finger entered her vaginal opening at all. So that's part of the issue, Your Honor, is that these questions would not have been appropriate even on direct. So the prosecutor is not able to just direct the witness's testimony in this way, regardless of whether it's on direct or redirect. This is not a question that seeks clarification. This is a question that seeks to change the witness's testimony. That, we believe, is misconduct. And allowing this, by the court allowing this, I think this was very unfair to Mr. Reyes. This should not have been allowed. It should have been stopped. There should have been a limiting instruction. There should have been all kinds of things. So that didn't happen. With respect to the issue of the burning versus the pressure, the victim testified she felt pressure after the event, like something is trying to shove. That is not the same thing as saying, I feel pain inside, or, I mean, that could be any number of different things. That certainly could support an allegation that she felt pressure because somebody had been pressing her or touching her or rubbing her. That is not the same thing as saying, I felt burning. The reason this matters so much is because this ends up being, this burning language ends up being 50% of the evidence that's referred to demonstrate that the victim actually felt something later on to substantiate her claim. It's significant. And in some instances, I would argue that that is actually, if somebody felt burning inside their vagina, I think that is stronger evidence than somebody feeling pressure. So it's incredibly problematic. It's incredibly prejudicial here. And I don't think that we can say that the jury was not affected by that. Then with respect to the criminal history, Mr. Reyes wasn't asked about his criminal history. The court has the questions that he was asked. Not one opened the door to this wide open range of criminal history. The questions were directed to whether he had been convicted. And again, they track what the language is that we find in the evidence code. So this argument that this somehow opened the door to this cavalcade of information has to be rejected because it's just not there. It's not in the record. And I would also point out, it is not the defense's job to make the prosecution's case for them. The defense does not have to ask questions simply because it's more convenient for the prosecution to be able to cross-examine and question the defendant. Finally, with respect to that as well, when we look at the ruling from the court says that this information was introduced to impeach Mr. Reyes. But again, there was nothing on the record that suggested Mr. Reyes needed to be impeached because there was no evidence that nothing to indicate that he answered untruthfully. It was all truthful, so it was therefore inappropriate.
What about that first question that says, I guess before we begin, as far as any criminal history, so he's asking about criminal history, have you been convicted of a felony?
That's not what the question was. So the question actually says, I mean, he starts maybe with that, and then he says, the question is, have you ever been convicted of a felony? He doesn't say, tell us your...
Reference to criminal history alone is not sufficient because there's no question on that.
That is correct. So, and he's very specific. Now, it's unfortunate, sometimes witnesses do answer questions before they're completed. That does happen at times, but there's nothing in there to indicate that that was appropriate at all.
But wasn't his credibility at issue with respect to whether he picked up his granddaughter every day or not? There were witnesses that contradicted that.
Well, that may have been with respect to that, but this issue is not whether he was convicted of prior crimes. That there was nothing to indicate he wasn't truthful about that. So the credibility issue, I mean, his credibility may have been in question, but also with respect to those 4 witnesses, none of them really had anything to do with whether these things actually happened. They were just talking about the schedule. And again, this is something that's 10 years later and the jury's entitled to know, well, this is my recollection of this. This is somebody else's recollection. But as far as his actual credibility, his credibility was not challenged with respect to whether he had ever been convicted of a felony or a misdemeanor. The other thing I would say is that to the extent that this information was brought in, supposedly, I mean, now the argument is it was brought in to refresh his recollection, and that's why the indictment was brought in. He never said, and the question was never asked, hey, do you remember anything? And he said, no, I don't. Nobody ever asked him, well, would it help you to see something? Would that change your recollection? That was never asked. It was, hey, look at this. So there's a difference between not having a recollection at all versus having something that maybe can be rehabilitated by seeing some other thing. And that distinction wasn't made here. So I think it was inappropriate under that reason as well.
All right, thank you.
Thank you.
Ms. Kirigua, Mr. Tennyson, the court will take the matter under advisement. We will be issuing a written opinion and will now stand adjourned.
All right.